Welcome to the midweek edition of Legal AF with your anchors, defense attorney Michael Popok and former prosecutor and defense attorney Karen Friedman Agnifilo. Trying something new for a change. I'm going to spice up the intro a bit and keep it short and sweet so we can get right to the topics of the week. We're going to debate and analyze 4 top stories, all that hit within the last few days or even last few hours. First, developments in the Georgia election interference case, including Ken Chesebro getting permission to leave Georgia to cooperate with the feds, and Fani Willis making plea deal decisions about who else, Trump, Giuliani, and Meadows. If you follow closely things that Karen Friedman Agnifilo says, that won't come as a surprise to you. 2, we'll talk about developments in week 8 of the New York civil fraud case. It's all about materiality and intent as Trump puts on another Deutsche Bank witness and tries to have the monitor, former federal judge Barbara Jones, testify, presumably on his behalf, at the same time or a day later that she just reported today that Donald Trump and his organization moved $40 million of cash out of the bank accounts without letting her, the monitor, know about it. Probably not a good thing to do when you're trying to call the person, put him up on the stand. 3, Karen and I will talk about developments in the D.C. election interference case with Judge Chutkan, keeping this case on track for trial in March as Trump files ad nauseum motion after motion to slow it down. And new disclosures have come out about a sort of a related issue in Mar-a-Lago and the prosecution there, and which lawyer is now testifying against Donald Trump today. You need a scorecard keep track of all of Donald Trump's current and former lawyers and whether they testify before the grand jury, whether they're cooperating with the Department of Justice or not. And then lastly, we'll talk about developments returning to New York in the Stormy Daniels hush money cover-up business record fraud case by the Manhattan DA's office. Where else would we be with Karen Friedman Agnifilo on the show? That is still on the books to go to trial, we think, in March of 2024. But we'll get down to it. All this and so much more on the midweek edition of the Legal AF podcast, where we sit and analyze at the intersection of law, politics, and justice so you don't have to. Karen, how you doing today?
I'm doing great. How are you?
I'm good, and I feel very confident. I feel confident when you're in that particular room of whatever room you're in. I like that room with those books and that bookcase.
Thank you. That makes
Yes.
me happy. Yeah, I mean,
Yeah.
it's interesting because you and I we travel, we go, we're doing things in different places, but we never miss our legal AF, so we have to do it wherever we are. So now I'm back in my normal place. So I'm
Yes, me too.
happy to do it.
Good. I'm glad to see you in your normal place, here on Wednesdays midweek on the show. Let's get right into it. Let's kick it off with something. I'll frame it, turn it right over to you. You said, and I'll paraphrase, I'm never good at quoting, 3 or 4 episodes ago, no way Fani Willis, right? Prosecutor to prosecutor, no way. She's going to offer a plea deal to the following 3 people, if I remember correctly. Donald Trump, Rudy Giuliani, and I think you said Meadows.
Yes.
So if you're playing Karen Friedman Agnifilo bingo, okay, you can now yell out bingo, because that is the new reporting about the Fani Willis and who she is and who she is not. More to the point, going to offer a plea deal to. Take it from there, Karen.
Yeah. So look, this wasn't something that anybody who's a former prosecutor could make that same guess. So it wasn't that hard to kind of see that that's where they're going. And the reason is because when we as prosecutors, they, whatever, when we are deciding who to make a deal with, you typically don't flip down, you flip up. And what that means is there's a hierarchy when you are prosecuting a group of people typically, right? There's typically, like, if you think of the mafia or a violent gang or any other sort of criminal enterprise, which she is prosecuting under the theory of RICO, which has to do with criminal enterprises, there's a hierarchy and a structure. And you've got people at varying levels of culpability. And whoever the upper echelons, the top people are, the ones that you're really looking to potentially convict and hold responsible. And in this particular case in Georgia, it really looks like those are the ones that are most culpable. And so I think that it makes sense that that this is where we are and how we got here. I also think she could have drawn the line with some of the lawyers as well. I think Eastman and Chesebro, for example, could have been or could be on that list as well, because they're the enablers, the architects, whatever you want to call them, of this entire scheme to defraud the voters of Georgia of their rightful elector or electors. And so I could see also them being on the list, but I think the reason she's deciding to get the lawyers out of the case, which is what so far it seems like she has done, is to try to neutralize any advice of counsel defense and get them to cooperate, because Trump has signaled that that's going to be one of his main defense, that, look, I was just relying on my lawyers, my really smart lawyers. They came out and they told me that this was okay. And that's going to be one of the defenses, right? I'm not a lawyer. How was I supposed to know? I rely on lawyers to tell me what to do, just like he's just typical of what he's doing in his civil fraud case in New York, right? I relied on the accountants. Like he never wants to take responsibility for anything and always blames somebody else. So the way this all seems to come out. So the Guardian, a reporter, Hugo Lowell, is the one who broke this story. He's somebody who is a pretty good, really, I think, a really good reporter, and he broke the story that she's not making offers to Trump, Meadows, and Giuliani. And how did he figure it out, or how did people figure this out, other than just it makes sense? And I think what I'm gleaning from the reporting is, there was a report by John Eastman. There was a request from John Eastman, one of Trump's former lawyers, who asked the judge, McAfee, to do this kind of strange, divide up the case between two groups, let Trump go by himself and let everybody else go in two separate groups. And, this way Trump can go at some other future time. He's busy running for office and he needs to do that. So let's not worry about him and worry about security from the Secret Service, et cetera. I want my trial to end before, I want it to be completed in 2024. I don't want it to go into 2025 the way Fani Willis has suggested, because she asked for an August of 2024 trial date. And she said it'll go into 2024. So Eastman said, look, I don't want that. I want to go sooner. And the reason I think that's significant is Fani Willis said to the judge, when she said, look, Judge, I want an August trial date, and anyone who has gotten an offer, I'm going to give them a deadline of June 21st to take this offer or not. Because think about, anyone can plead guilty at any time in a criminal case, right? A defendant usually pleads not guilty, and then at some point they can decide to either plead guilty or go to trial. Every defendant has that right. But whether or not to offer a plea or a deal or cooperation is 100% in the control of the prosecutor. The prosecutor decides by themselves 100% whether or not they're going to reduce the charge for nothing or for an exchange for something. And what Fani Willis is saying, anyone who I've given a plea offer to, you have until June 21st to accept it. After that, it's plea to the charge or go to trial. And she wants to know, who are her witnesses going to be? Who is she going to trial against with all the defense? I think there's 14 people left. She's going to want, or 15 people left right now. They'd have to at least probably have two trials but she's going to try to winnow it down further. And she said, and what Eastman said was, look, let's make all those dates even sooner, right? Let's move all those dates forward even more, not June 21st. Let's make it even shorter so that we can all go to trial, et cetera. And I think that little kind of signal of him wanting to do this and moving the plea deadlines different, et cetera, I think that's how we know who got offers and who didn't. Because look, there's probably some kind of joint defense discussion. The defense attorneys are talking amongst themselves. And I'm sure that they said, hey, did you get an offer? Did you get an offer? Like they're sharing that information about who got what. And it's looking like Meadows, Trump, and Giuliani's lawyers had to sit there silently and be like, oh, we didn't get an offer. And that's how I think this is coming out. That's, again, this is me gleaning and reading tea leaves. Let's just be clear. But I think just given everything that's going on there, I think that's where that is coming from. And just one more thing before I turn it over to you. I still find Meadows to be the biggest head scratcher of all, because I don't understand how he can both be at the same time somebody who's so seriously responsible that he's not even going to get a plea offer, and it's plea to the charge, and we're going to trial against in Georgia, and he's not even an unindicted co-conspirator in Jack Smith's case. It's just, to me, like, if you would think that Jack Smith would view him as seriously or as important, or as, he's at least an unindicted co-conspirator, because it doesn't look like he's cooperating. So I don't know. That's still the head scratcher for me, but that's my reading the tea leaves of everything that's kind of going on in Georgia.
With Meadows, I agree with you with the mismatch. I think it's a timing issue. I think at the time they brought the indictment, Meadows, they still held out hope that Meadows would cooperate even more than he was already cooperating to the limited immunity deal that it looks like he had. And then they have decided for various reasons since then not to do what they did in Mar-a-Lago, which is to bring a superseding indictment, which may have captured, no pun intended, caught Meadows. But because of things that you've actually said, and we've said in past episodes of Legal AF, where they don't want to have anything on their side delaying the March date. They don't want to F with, to paraphrase the title of our show, they didn't want to F with the indictment and let Donald Trump just shoot at that one and not kind of raise the issue. So I think it's more of a timing issue. And the reporting is that it's also Fani Willis signaling to everybody else who should like to get to settle. If you're waiting around and you think I'm going to settle out this case and plea out this case at the top, and you're going to wait till the very end, don't do that, because I'm not going to plead this case out. I'm going to try this case in the summer against these three guys and whoever else is left. So you're running out of time, folks, as on your flip up metaphor, to come in and talk to me. And then the other thing I'll hit here briefly is that Ken Chesebro, speaking of attorneys, that Fani Willis has worked hard to kind of get out of the way and have them cooperate. Ken Chesebro, the architect of the fake elector scheme, or what I call one of the midwives giving birth to this scheme, along with John Eastman, constitutional half scholar, is a convicted felon now because he pled guilty to one felony count in Georgia, but is fully cooperating. Interestingly, of all of the videos that were released to the media of the proffer, the cooperating testimony of Sidney Powell, Jenna Ellis, and Chesebro, the only one that didn't come out was Chesebro. So you got to think, I mean, there was already bad stuff against Donald Trump in those, and I know that Misty Hampton, the Coffee County election supervisor's lawyer, is the one that admitted that he really leaked all of the videos. Yeah, right. He like, I got a confession to make, Your Honor, before you move on to the next person on the Zoom. I did it. We never could figure out why, but he didn't do. We were like, God, there's bad stuff in there against Trump. Every one of them says something really bad against Donald Trump. Why would he think he'd want that released? But he didn't release Chesebro. So you got to think Chesebro's got to be really bad. And he now has asked for permission because he is a convicted felon that is subject to the court's control under conditions of release. And he's asked Judge McAfee to give him a hall pass to go visit other states and the feds. This isn't a class trip, everybody. He's not going to Washington to go to the Smithsonian or check out the new museum. He's going to talk to Jack Smith. He didn't say it in his papers, and the judge was like, where do I sign? One line, granted. And now he's going on a whistle-stop tour to Nevada, Arizona, to go talk to the attorney generals there about their fake elector investigations and his role in it, dumping on Donald Trump all along the way, and talking to the feds, talking to Jack Smith. We always said and we said it certainly on the midweek edition, Karen, that the people that were cooperating with Fani Willis are going to have their ticket punched because they're going to have to cooperate with Jack Smith for many, many reasons. They've already proffered and they have a duty to tell the truth. And so the first one that looks like who needs to ask permission because he's a felon, Sidney Powell pled guilty to a misdemeanor. Jenna Ellis was a misdemeanor too, right, Karen?
Yeah, I think so. Yeah, yes.
I think the only felon is Chesebro.
And yes.
So he probably had the greater conditions that had to be modified in order to go do that. For all we know, Powell went too. Sidney Powell went too. For all we know, we just don't know that.
She's a little too crazy for Jack Smith. I don't see him. I don't see Jack Smith putting her on. Maybe Jenna Ellis, but if you're Jack Smith, you want Ken Chesebro and John Eastman 1,000%. to completely debunk this advice of counsel.
But Eastman, and he's not going to get Eastman because Eastman is still out there drinking the Kool-Aid. You know, like, I want to be tried. I don't have Secret Service. I'm burning through my wife's retirement money. And can't you try me quickly? I mean, I'm only barely paraphrasing what he filed with the court in Georgia. So we'll continue to follow developments in Georgia as Fani Willis moves towards her August trial date and who's going to be on that dance card, who she's going to be trying. We know Donald Trump's going to be there, but who else is going to join? Let's take a break from criminal and criminals. And in the rest of our podcast, we'll next talk about the developments in the New York civil fraud case, including new Deutsche Bank witnesses that want to talk about how excited they were to have Donald Trump be their customer. They're willing to just give him money, hand over fist. I guess they think that's supportive testimony for their defense. And also that we just learned today from the Monitor that she had to go look in the bank statements to figure out that $40 million was missing from the Trump organization while they've been under a court-appointed, court-ordered monitor. That's not a good thing. And then we'll turn to D.C. election interference and wrap it up with your old stomping grounds, the Manhattan DA's office, getting ready, maybe, for the Stormy Daniels hush money cover-up case. But first, one of my favorite points in the podcast, a word from our sponsors. Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? If you wake up too hot or too cold, I highly recommend you check out Miracle Made's bed sheets. Inspired by NASA, Miracle Made uses silver-infused fabrics and makes temperature-regulating bedding so you can sleep at the perfect temperature all night long. Using silver-infused fabrics inspired by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, so you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them to stay cleaner and fresh 3 times longer than other sheets. No more gross odors. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands and feel as nice, if not nicer, than sheets used by some 5-star hotels. Miracle sheets are the perfect gift for your spouse, friends, or family who doesn't want better sleep and luxurious feeling bed sheets. And since these come with 3 free towels, you get 2 gifts in one, just in time for the holidays. Stop sleeping on bacteria. Bacteria can clog your pores, causing breakouts and acne. Sleep clean with Miracle. Go to trymiracle.com/legalaf to try it today or gift it to someone special this holiday season. And we've got a special deal for our listeners. Save over 40%. And if you use our promo LegalAF at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LegalAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself, a friend, or loved one this holiday season. Now it's time for a word from our show sponsors, Highland Titles. Highland Titles sell a unique gift with a legal twist. In the Land Registration Act of 1979, lawmakers in Scotland legally defined a souvenir plot of land. This is a plot of land so small, most often 1 square foot, that its value is solely commemorative or sentimental. So you can buy a square foot of Scotland for just $30. Why do people do that? Well, Scottish landowners are traditionally given the courtesy title of laird. The English translation is lord, and the female equivalent title is lady. Buying a plot of land from highlandtitles.com will enable you to legitimately style yourself as a lord or lady of the Glen. You get a legal right to a plot of land you can visit at any time and a luxury gift pack too. The gift is so good they made it legal. Check it out at highlandtitles.com and use the discount code LEGAL25 to get 25% off your order. Welcome back, Lady Karen Friedman Agnifilo.
By the way, I was reading the comments during the commercials, and there were people commenting on my books, and some people were like, "It's not real. It's a background.
It's real.
And
go grab a book.
It's real." And some people were also commenting that, oh, they liked it better when I'm sitting in the corner versus. So I moved my chair and my desk to show everybody it's real. And now now we did it in the corner. So.
Well, first of all, as a close friend of yours, nobody puts KFA in the corner. For those that don't remember that movie,
that's a great movie.
Dirty Legal AF. I'll just leave it at that.
Dirty
All
Dean.
Right. All right, let's get back to what's going on in the New York civil fraud case. Just so everybody, I want to just we do have new people that join, so we don't like to be repetitive, right? We like to be episodic and a serial at the same time in terms of building on each week's legal episode, legal study teachings. And so the judge did already rule twice early on in the case. That's why there's a monitor in place, that it was more likely than not that Donald Trump's organizations were committing persistent fraud, requiring that there be a monitor installed over them to keep an eye on all their books and records, finances, and bank accounts and all that. Then later, just recently, about 7 weeks ago, on summary judgment, the judge found, as to count one of the petition or the complaint by the New York Attorney General, that it was more likely than not, preponderance of the evidence, that Trump and all the Trump entities, financial entities, were committing persistent fraud, what we call a standalone persistent fraud claim under Executive Law 63-12. And for that, you don't have to prove materiality or even intent. You can accidentally commit persistent fraud in New York as a business and still get shut down by the New York Attorney General in combination with the judge. But in order to go one step further and prove the other 5 counts that are remaining, that's the difference between what the judge already ruled and what's going on now. What's going on now is that the New York Attorney General has to prove both materiality, meaning it wasn't just a small de minimis amount of money involved. It was something material to the decision-making of somebody or a counterparty or stakeholder or lender or insurance company or whatever, and that there was an intent to do it. At the end of the day, I'm not sure it all matters, because he could do, under the first count that he already found on summary judgment, probably what he's going to do under all these counts in terms of the complete and total annihilation of the Trump organization and its assets. But we're along for the ride, and it's interesting. First part of the case went on for six weeks or so in the hands of the New York Attorney General, her team of valiant lawyers. There's about 10 of them. They all took turns at putting on 25 witnesses, thousands and thousands of exhibits, pages of information, incalculable amounts of data that Judge Engoron and his principal law clerk, who sits right next to him, have to sift through in order, as the trier of fact, to render the decision. That's what we're watching. And now we're in week 8. And we heard just this week that Donald Trump's coming back. He's going to come back for another, who knows what. Get in trouble again, be found in contempt again. Maybe we'll see Eric Trump come back. But right now, they're in that part of the case. They're plotting through bringing in bankers. The primary lender for Donald Trump during all these years was Deutsche Bank. It isn't any longer. I don't want to touch him with a 10-foot pole, but it was for a long, long time. And I'm talking hundreds and hundreds and hundreds of millions of dollars. And so they've been putting on these bankers to say, we love Donald Trump, blowing kisses. Oh, we gave him the biggest toaster we could find when he opened his account. We loved him. And we would have done anything for him and lent him any money. But that's the banker. The banker is not making the loan. I got news for people who don't understand how banks work. like the witnesses that are testifying, not our audience. The banker's the front person. The loan gets made in the back by the loan committee and the underwriting committee, who set requirements. Something like requirements. You can't just come in and say, "Hi, I'm Donald Trump. Where's my money?" Which is how they're making it sound. You have to have net worth of a certain amount. In this case, $2.5 billion. You have to have hundreds of millions of dollars of liquid assets and cash on hand. And you have to really have those things, not just say it. And that's where we're watching this hand-to-hand combat between the New York Attorney General and these bankers, as the judge has made clear in most circumstances, you don't need a victim. I don't need a victim. I just need materiality that they would not have lent, or it was a material to their decision to make the lending, what the statement of financial condition looked like for years 2014 through 2021, yes or no. That's the only issue he's really trying to get to the bottom of. So, Karen, why don't you comment now on these parade of witnesses already that ended on before Thanksgiving and picked up now, and then why don't you touch on what we learned about? I did a hot take on it, but touch on it here. What we learned about the movement of $40 million of cash without not permission, but without reporting it to anybody.
Yeah, I mean, look, they did put on a couple of these bankers, and it's interesting because look, we got reporting and live tweeting from the courtroom, but we don't have transcripts, right? I didn't see any transcripts. I read everything I could find on people who were there about questions that were asked of these witnesses, and so one of the witnesses that Trump's defense team called was this Deutsche Bank private wealth employee, Rosemary Vrablic. And she was talking about how in 2011, she was excited to go, they called it whale hunting, which I guess is seeking a business relationship with a high net worth individual. Ivanka was a liaison, Don Jr. was a liaison, and they were very excited about having the Trumps as a client, wanted to meet the dad. At one point, she said in 2014, I think, that the family's in the top 10 revenue generating names of asset wealth management, et cetera, et cetera. And, it was great, except what I didn't read or hear or see is the Trump lawyers asking her the ultimate question. Basically, was it material? Did it matter? Did you rely on this? And you would think if you're calling them as a witness, you would know what they were going to say, and you'd be calling them to say something like that. And so the fact that they didn't ask, if they didn't, because I think if they did and she said, no, it didn't matter, I'm sure we would have heard that and read about it. But it's just, I found that kind of a glaring omission. But then at the same time, of course, the prosecutor also didn't ask that question either. And again, if I was sitting there, I'd wonder, okay, it wasn't asked. That must mean the answer is yes, of course that would have mattered. And so I'm looking forward to reading more about it, maybe seeing the transcripts, because I really think that if you're going to put these bankers on, as you just said, that's the ultimate question. You got to get to that ultimate question. And I think that the government did a great job at showing her during cross-examination certain emails, right? Like there was an email from one bank committee executive member, what you just said, how it's a committee that makes these decisions, that basically said, I support this transaction, but we need ironclad, full recourse under all circumstances. And, this is sorry about that, but this is a requirement in private banking, which basically means we can seize your assets in the event of default. And, so there are emails, it seems, to show that, right, that this did matter. But it doesn't appear that anybody kind of ask that ultimate question. So I thought that was kind of interesting. And you're a very experienced civil practitioner, so I'd love to hear your thinking about that and why it wasn't done. But as just a trial lawyer, if it was my witness that I'm putting on, and he was the Trump witness, I'd know the answer to that, right? And I think I'd want to find someone. They promised, right? They promised that they were going to put on witnesses to say that you're going to hear from bankers that said we would have done business no matter what. This didn't matter. I mean, just because she loved him as a client, at the time, I don't think that really matters to this ultimate question. So they haven't delivered what they promised they were going to deliver yet. Because again, I'm fairly certain that we would have heard about that if that was the case. And they also recalled Patrick Burney from the Trump organization as well, to the witness stand. So I look forward to hearing more about what he said. But so they make a lot of promises about what they're going to show, but so far I think they have failed to deliver that promise. And getting to the monitor, Barbara Jones, who's a former federal judge, she actually, believe it or not, was the former. I met her when she was the chief assistant at the Manhattan DA's office, which was a job that I had many years later. But when I was a young prosecutor in the 90s, she was the chief assistant at the Manhattan DA's office, and then she left there and ultimately became a federal judge, and then now is in private practice. She's a very, very smart, very well-respected, take no nonsense judge or former judge, and I wasn't surprised that they would have appointed her to this monitor position. But she, as a monitor, she has to periodically report to the court, and what we saw today was that basically that Donald Trump, or that the Trump organization, failed to report about $40 million worth of transactions. And they're required to report up to, I think it's 5 million, any transaction that's $5 million or more. And frankly, it's just very interesting that she says, oh, they failed to report, and we're putting in heightened controls now. But the whole thing, the way she said it was very much kind of gives them the benefit of the doubt, as if it was a mistake. I don't know. I don't think the Trump individuals are very smart, but they're no dummies. They're scheming. These are scheming individuals who, this was not an oversight, in my opinion. And some of the money it looks like went into escrow for E. Jean Carroll, which is great. I hope she gets her money too. So I found that's what I thought was sort of interesting in this. And meanwhile, don't forget, Popok, they wanted to call Barbara Jones to the stand to talk about how great they're doing. So I think that's interesting. The judge denied it, right? The judge said, no, you're not going to call her to the stand. But what was she going to say? No, they're not great. We found $40 million of unaccounted, transferred money that's unaccounted for. So I don't know why they wanted to call her, given that.
Well, yeah, let me see what I can comment on there. That makes an interesting point, because you covered a lot. The Barbara Jones, they hoped would, and I talked to legal AF people about this, having been involved in receiverships and monitors before. It's sort of weird not to call the receiver the monitor, even though the case isn't about receivership or what she's monitoring, if they think that she's going to have some helpful testimony about the operation of the company, inconsistent with the view that's been painted that it is a persistent, fraudulent company. The problem with that is that she was only hired in 2022, and the case is about all the dates before that. So the most that she could ever say is, assuming this is true, the most she could ever say is, since she's been there, she hasn't observed anything that would rise the level of persistent fraud, and she's been watching for it. But that doesn't mean that in the 2014 or 2021 time period, about the statement of financial conditions and the assets, which is what this case is about, that's the fraud. The fraud is baked into the statement of financial conditions for Donald Trump that he signed and endorsed and participated in the rendering of, that have inflated his assets to render him a triple billionaire instead of the single billionaire that he probably was at any given time, because he had to get over certain hurdles by the bank in order to borrow the money and do all the rest. So Barbara Jones, I don't think would have been very helpful, although I was only slightly surprised that Judge Engoron didn't allow her to testify, both finding that the request to have her testify by the Trump group was late, and that she was an arm or an officer of the court serving in an independent role, and he wasn't going to allow her to take the stand, found it to be irrelevant. I think you had a good comment in one of our prep sessions um, about him drawing a line so it wouldn't be a slippery slope to them trying to call the principal law clerk, right, to get on the stand. Wasn't that one of your comments when we were prepping?
Maybe.
Well,
I don't
somebody
remember.
made it.
Somebody made it.
One of the
I'll
leaders.
I'll take credit for somebody.
One of the leaders of Legal AF. We were texting back and forth, and that's what we do when we see new information. Our producer just said Salty said it. No, I don't. Maybe Salty said it.
I bet Salty said it.
Salty, did you say it? I'm looking at my chat. Okay, I didn't think so. But you've gotten such an education over the last 2.5 years in Legal AF. You could have said it. So that he doesn't want the principal law clerk being called on the stand. I mean, look, and we'll get to the DC election interference case there, but buried in a recent motion, I just did a hot take on it, is a line in there that says, of course, this is from Trump, of course, senior Department of Justice leadership, Merrick Garland, Lisa Monaco, the Deputy Attorney General, Jack Smith will be witnesses in our case. In what case, Karen, in your 30 years, is the prosecutor, unless there's a prosecutorial abuse case, which therefore the indictment gets dismissed anyway, does the defense gets to call the prosecution to the stand? No.
Yeah. So, well, no, I don't know.
All right,
I've been called to.
Right.
I've had to do it.
Talk about it. That's what I want to hear. Tell me.
Yeah.
About it.
So this is the thing. Prosecutors, the one of the number one rules of being a prosecutor is don't make yourself a witness because you don't want to be called to the stand. So, for example, if we would take a statement from somebody, you'd never do it alone. Even if it's recorded, you would always have someone there, because you need to be able to put someone on the stand other than you. And so you try not, and so like even when you talk to witnesses, right? And if they change their story, like say you're talking to a witness and you get this whole, I always had a paralegal with me or somebody taking notes, because otherwise if they change their story or they flip or something happens, I don't want to get myself off the case and now have to be a witness. So it's rare and it doesn't happen often, but it's something you have to be somewhat concerned about. And I've even had to put a second seat on a case before during a trial, so that in case I was called as a witness, I would have to do that. But look, you also it's complicated in front of a jury too, but it's possible. But I'm sure Jack Smith and Lisa Monaco, who are the best there is, frankly, did not make themselves witnesses. I mean, it's kind of prosecution 101, so I'm not worried that there's anything that they could be required to be to testify and be called to the stand.
Look at, you always have to read these different things and piece it all together here on Legal AF. And so I think that could have been one of the reasons Engoron was like, no, you're not doing the monitor. You're not putting Barbara Jones on. Pass, hard pass. What else do you have in terms of witnesses today? And that's what we're watching. In terms of answering your earlier question, why are they putting these people on? Or in the chat, I saw, why is Trump coming back? Why not? I mean, from a Trump perspective, he only got to testify in response to questions that were cooked up by the Attorney General, right? They were their cross-examination questions. Now he gets to answer softball after softball. We saw what happened the last time he got on the stand. It was a whole bunch of pontificating and soapbox and speechifying that had nothing to do with answering the question, which led the judge to say, quite rightly, which now infamously, I'm not here to hear him talk. I'm here to hear him answer questions. So we'll just see another version of that, because it'll suck the air out of the room and he'll win the news cycle that day, and he'll raise another $500,000 or whatever it is. So that's the reason why for that. To answer another question in the chat, will they get penalized for the $40 million being transferred? No, because it looks like from the letter writing, which, as Karen, you pointed out, is very diplomatic, to say the least. Although I think there's a twist here. It says in her report on her letterhead, the former judge, that after she had figured out that 40 million had left the building, had left the bank by looking at the bank statement. She pointed it out to the other side, to the Trumps. They came back and talked to her about it, told her it was for putting up I think it's to put into the court registry, the $5.5 million for the appeal bond for E. Jean Carroll. And then I didn't even know Donald Trump paid this much in taxes, but like 29.
I saw that. Yeah. I was like, he pays taxes?
$39 million in taxes.
Yeah.
I was shocked by that number. And she said, wrapped him on the knuckles, like, don't ever do that again. It's $5 million. And to be clear, she's a monitor. She's not an approver. She didn't have to approve the transactions. They can do whatever they want. They want to like blow the money on who knows what. She'll just write it down dutifully. They blew $500,000.
Yeah. What's a monitor? Will you tell people?
That's it. Yeah.
The
monitor is what it sounds like. She has to report. The thought process is by having somebody stand over you, you will do less fraud. And because she will be able to report it. So she's able to peer in transparently to all of the financial records in real time at any time and be able to demand reports be made to her from the accounting system, accounting ledgers, and bank accounts. And then she's reconciling. She's got a whole team. It's not just Barbara Jones. Believe me, that's a great gig if you and I could get it. She's billing $5 million a month to the Trump organization for this monitorship, I am sure. She's got 15, 20 people and paralegals working this thing, reconciling bank statements against internal accounting. But all she's doing is reporting. Today, $3 million got spent to upkeep of a jet, a private yacht, to pay off, Ivanka's student loans, whatever it is.
So what's the heightened reporting that now she's...
And this is where I think the twist comes in. So in it, because she's got to do her job too, and she can't act like it was no big deal. So it looks like they had a conversation, the Trump side and the monitor, which the monitor reprimanded them and said, you better agree to something because I got to go to the judge with something. So they agreed, the Trump organization agreed to heightened monitoring without definition, which apparently I don't even know what it means. And it's not defined in her report, which is where, sorry, I got a noisy, wow. Can people hear that? Streets of New York, ladies and gentlemen, real time, 8:42 p.m. I would normally when I do a hot take, I wait for that to end, but we got to keep going. So what's going to happen is she's not a judge. She's a former judge. And so the judge, I think, is going to have to amend his order to make a finding about this. And then he'll have to decide whether this enhanced monitoring that she's agreed to is sufficient, or he's sufficiently pissed off that he's going to impose something else in terms of a sanction or a penalty. So I guess it's a long-winded roundabout way to answer the question in the chat. Could there be a penalty associated with the 40 million? It looks like the monitor doesn't think so, but the judge could. And this judge and Goron, I don't think he's going to be happy that $40 million got moved without the monitor knowing about it, and she had to catch him in the act. So, I think we've covered that. Anything else you want to add on the New York case? Then we'll move on to DC.
Yeah,
so we're going to talk in the remainder of the podcast about the DC election interference case and all the filings Donald Trump has made and the new rulings that Judge Chutkan has made. And even Thanksgiving was no holiday. Ben and I reported it on Saturday about all the filings related to the gag order, which we're still waiting for the 3-judge panel there to rule. Salty, we got a ruling in the gag order for tonight. Okay, thank you, Salty. Salty wrote no. Thank you. And we'll end it with returning to your old stomping grounds, the Manhattan DA's office. Speaking of law and order, Karen, you'll tell people why I'm saying that at the end.
Okay.
But we'll do all of that. But first, my second most favorite point in the podcast, another break for our sponsors. This holiday season, you might be looking for nutritious, convenient meals to keep you energized on jam-packed days. Factor, America's #1 ready-to-eat meal delivery service, can help you fuel up fast for breakfast, lunch, and dinner with chef-prepared ready-to-eat meals delivered straight to your door. Too busy with holiday plans to cook but want to make sure you're eating well? With Factor, skip the extra trip to the grocery store and the chopping, prepping, and cleaning up too, while still getting the flavor and nutritional quality you need. Factor's fresh, never frozen meals are ready in just 2 minutes, so all you have to do is heat and enjoy. Skip the stress of meal prepping over the holidays with Factor. Choose from more than 35 weekly flavor-packed, fresh, never frozen meals that support a healthy lifestyle and meet your meal preferences. All delivered right to your door and ready to eat in 2 minutes. Level up with Gourmet Plus options, prepared to perfection by chefs and ready to eat in record time. Enjoy premium ingredients like broccolini, leeks, truffle butter, and asparagus. Looking for calorie-conscious options over the holidays that also taste great? Try delicious dietitian-approved calorie-smart meals with around 550 calories or less per serving. Need an extra boost to support your wellness goals and feel your best during the holidays? Try Protein Plus meals with 30 grams of protein or more per serving. Enjoy extra convenience any time of day with an assortment of more than 45 add-ons to suit various preferences and tastes. Choose from breakfast items like our delicious apple cinnamon pancakes, bacon and cheddar egg bites, and potato bacon and egg breakfast skillet. Or for an easy wellness boost, try refreshing beverage options like cold-pressed juices, shakes, and smoothies. This November, get Factor and enjoy eating well without the hassle. Simply choose your meals and enjoy fresh, flavor-packed meals delivered to your door, ready in just 2 minutes. No prep, no mess. Head to factormeals.com/legalaf50 and use code legalaf50 to get 50% off. That's code LegalAF50 at factormeals.com/LegalAF50 to get 50% off. If you're like me, morning coffee, non-negotiable. But I was tired of either waiting in line for an overpriced cup or settling for gritty, bitter coffee at home. Now I've switched to using AeroPress and I'm never going back. It's so easy and convenient and incredibly unique. I never knew coffee at home could taste this good. AeroPress is like a French press, only better. It's the only press that uses a patented 3-in-1 brew technology, combining the best of several brew methods into one portable device for a completely unique and delicious flavor profile. Smooth, rich, and full-bodied, without the bitterness and grit found in other presses. And as a bonus, AeroPress can brew thousands of recipes. AeroPress travels better than others too. It's compact and incredibly durable. That means you'll never have to endure terrible coffee at the hotel, on the job, or on an adventure again. It brews and cleans in less than 2 minutes. Just add medium fine coffee grounds, pour in hot water, stir for 5 seconds, brew for 30 seconds, then press into your favorite mug and enjoy. There's a reason why AeroPress is the barista's favorite home brewing tool. AeroPress is the best reviewed coffee press on the planet with more than 55,000 five-star reviews. Thoughtful, proven, and under $50, AeroPress is the perfect gift or stocking stuffer for every coffee lover in your life this holiday season. Don't settle for less than the best. They'll love it. AeroPress is shockingly affordable, less than $50, and we've got an incredible offer for our audience. Visit aeropress.com/legalaf. That's AEROPRESS.com/legalaf to save up to 20%. That's aeropress.com/legalaf to save up to 20%. It's time to ditch the drive-thru, toss the French press, and say yes to better mornings fueled by better coffee. AeroPress ships to the USA and over 60 countries around the world. And we thank AeroPress for sponsoring our show. And speaking of our show, we're back to Legal AF podcast midweek. And now we're going to turn to the DC election interference case with Judge Chutkan. Karen, do you want to give like an overview of the recent rulings with Judge Chutkan on the Jan 6th issue and some things that you thought were interesting in some of the new filings by Donald Trump? Particularly, did you get a chance to read the one about his attempts to expand the definition of the prosecution team for discovery purposes?
I definitely read it, but I'm not sure I know what you're referring to.
That's all right. I did a hot take on that one. Okay. Just do the ones that you found to be really interesting about what Donald Trump's new positioning is, and then some rulings by Judge Chutkan, to keep the case on track for March.
Yeah, look, there's a lot going on in the case and a lot of filings, a lot of legal filings, decisions, things that we're waiting for, and it's hard to keep track of actually. So thank God you do so many hot takes on so many issues that we can keep up with them all. And I'm trying to do more of them as well. And there's been there were two motions that the defendant made that are not related but similar, and one of them was a motion to compel for a subpoena. It's a Rule 17C subpoena for documents, and really what he's doing is he's looking for documents from the archives, from the clerk of the House, the committee of the House on the Jan 6 Select Committee, the people who took over the Select Committee, and certain individuals who are representatives, Loudermilk and Benny Thompson of the House, as well as other individuals, including the General Counsel for the Department of Homeland Security. And they want documents, right? And they're looking for all sorts of documents that are in addition to the discovery that they already got. And interestingly, a criminal defendant is able to subpoena records, right, and to subpoena documents, but it's very different in a criminal case versus a civil case. Civil discovery and civil subpoenas is very broad. In a criminal case, it has to be very narrow and targeted and specific. It has to be relevant to your defense. It has to be admissible, and you have to be very specific what you're looking for. And this motion to compel discovery that he filed was essentially saying, look, the Select Committee, the Jan 6 Committee, they compiled this huge archive of information, and there was a letter that from Representative Barry Loudermilk, who was the chair of the Oversight Committee, who said that the Select Committee didn't transfer all the records to them, that they got certain things, but not all of them, that they claimed publicly that they accumulated 4 terabytes worth of materials, but the committee only received 2.5 terabytes. Therefore, there must be missing videos. There was also another letter saying that they loaned some records to the White House Special Counsel's office and the Department of Homeland Security as well. And so Trump's saying, I want that too, right? I want all of this stuff. Like they're really just looking for information. And what he basically said was in his papers that Rule 17C allows the defense to subpoena these documents. And, as long as they are produced before they go to the court, and then the court gives them to the defense, and that's under US versus Nixon. And it's important for an accused to be able to secure evidence that might be favorable to them. And they have a right to this information. And this is all relevant, right? So think about what they're asking for. They're saying, we got this amount of information, but we know there's more out there. So we want it all to see what's there, right? And that's what they're looking for. However, the judge already denied this and basically said Rule 17C of the Federal Rules of Criminal Procedure it's not for discovery, right? What this is instead is to expedite things before trial so you can inspect material ahead of time. It can't be a fishing expedition, and there's a limitation on the discovery that you can get. And Rule 17C requires a defendant to clear 3 hurdles. It has to be relevant, it has to be admissible, and you have to be specific. And essentially, at the end of the day, what he was asking for is just way too broad, and saying there are missing materials, that just doesn't cut it. That's not enough. And you have to be more specific about what you're looking for. You have to at least make an effort to say, I'm looking for documents that would tend to show something, or that may say something specific, because this is my defense. But he doesn't even make an effort to do this, right? He's looking for videos that he wants to use this is the one area, by the way, that I'm not sure I 100% agree with the judge. And that doesn't always happen to me, because I typically agree with this judge. One of the things he was asking for was videos. Okay. And this particular request is apparently Jack Smith transcribed any videos of any witness who's going to be testifying at trial. So we know that the Jan 6 committee took videos of many individuals, right? And they played some of the video, or snippets of the videos, and Jack Smith has all of those. And what they did was they transcribed them all and turned those over to Trump and the defense as part of discovery, because they're prior witness statements, which they have to do. But Trump wants the actual videos themselves. And Tanya Chutkan, the judge, actually denied that and said, look, the videos which he wants to use for impeachment purposes, he already has those transcripts, and the defendant provides no basis for concluding that the video recordings contain any impeachment evidence, like things that go to credibility, because credibility is always important. And he has the transcripts, and you can't merely seek to examine general categories of documents with the hope that they contain helpful information. But the reason I'm not sure I agree with this is, what about there's something called the best evidence rule in criminal law. You're supposed to be able to, transcripts aren't as good as the videos that they show. The best evidence rule is what's admissible is originals, not photocopies, or it's like the best evidence of something, the best version of something, the most original of it. And I just think that, look, yes, there are these written transcripts, but look, you don't see in a transcript, demeanor and tone and expression, or if somebody's eyes are looking all over the place and they're not really wanting to, answer a question. And those are all things that when you're looking at credibility that you would do, and I guess I think Judge Chutkan kind of put a carrot out there for Trump and said, look, if this is something you want, you have to at least make an effort. You have to give some reason why you believe the recordings are better than the transcripts. And they don't even make an attempt. So I bet they amend it, because that shouldn't be too hard to do. It should be fairly easy for them to say, look, the recordings obviously are better than a cold transcript, and credibility is an issue. I just think they didn't spell it out. So I don't know. I think in that particular instance, I think they're going to get those videos of the witnesses who will be testifying. I don't know. So that I found that motion and that decision, again, I agreed with everything she said, but that one little thing, I think they should get the videos, and probably will eventually. The next motion, do you want to comment on that before I go to the next motion?
No, I think you covered it well.
So well, thank you, Popok.
By the way, I don't want our chat to explode. I was not being condescending. I agreed that I thought that Karen, my partner, covered it well.
I didn't take it.
No, I don't think. No, you never do, and I never do. But people watching us, sometimes we talk in code, like, "Oh, Popok cut off Karen. Karen cut off Popok." Nobody's cutting off anybody. We're having a cup of coffee, having a conversation, hopefully mildly interesting. And I was complimenting my partner on covering something. When I have nothing to add, no value added, I don't need to say anything.
Well, thank you for the compliment, Popok. Anyway, so there's another motion that has not been decided. And this was a motion basically to compel discovery. And so the difference between what I just said, which was a subpoena, that's a motion to compel subpoena to third parties, right? To House of Representatives, Congress, the archives. Motion to compel discovery is a motion to compel Jack Smith to give more information to Trump. So that's kind of the difference. He wants more discovery from the special counsel. And the motion to compel discovery was couched in terms of there's Brady, Giglio, and Jenks material. And people are saying, what is that? So Brady material is anything that tends to exculpate or is favorable to or tends to support the defense, right? So that's what Brady material is. Giglio or Giglio material different people pronounce it differently, and Jenks material is impeachment material. Anything that can be used, well, Giglio is impeachment material. Anything that can be used to impeach a witness. So it's not necessarily like prior, things that exculpate you or things that tend to help your case in some way or help your defense, but something you could use to impeach a witness, like, the prosecutor, bought them, moved them to a new apartment, and because of safety reasons, they could make an argument that that's something that was to curry favor with the prosecution, and anything like that. It's like anything that you can use to impeach a witness. And then Jenks material is just discovery. It's just prior statements. It's things that you're entitled to. And so that's what they couched all this in terms of. And this motion was basically saying, we think there's all sorts of stuff out there. The indictment, Jack Smith in the indictment said that, that Donald Trump is responsible for the events of January 6th, right? Okay, if you're going to hold him responsible for it, you have to then, and that's in the indictment, I want every single thing you have in your possession of witnesses who've said he's not, right? Anything that says otherwise, whether you credit or not. It's not up to you, prosecutor, to make a decision about whether someone's credible or whether it helps the defense or not. I want anything about that. I want to know about informants or undercovers who may have infiltrated the group. That's something that I would say is also impeachable or Brady material. I didn't trust the election results, right? I thought there was political bias in the decision making of government officials. So I want anything that goes towards that. I mean, he's really looking for a ton of information. And the other thing is he throws in Jack Smith's face that he said in the indictment that whether Trump believed the election was stolen is a matter for trial, right? And Trump's lawyers saying, I agree with that. I agree with Jack Smith when he says it's a matter for the trial. Therefore, I want everything that could show that I had a good faith basis for believing that I won the election. And the reason that little section bothers me is I don't think him thinking even having a good faith, if he believed he won the election or that there was fraud in the election, that's not an element of any of the crimes, right? I might believe that the bank owes me money but they don't want to give it to me. I might have a good faith belief that it's mine. I can't go in there and steal it. I can't hold a gun up and go commit a bank robbery because I have a good faith basis that they're holding my money. So to me, I don't think that's an element of the crime. But, the fact that they've said this now opens it up to, because now they're going to litigate this issue at trial. It opens it up to now Jack Smith is going to have to provide absolutely everything that is in his possession that helps Trump prove that he believed that he won the trial. And so this hasn't been ruled on yet. But again, that's the problem with this, an indictment. That's a speaking indictment or a talking indictment. You're not just having a bare bones, elements of the crime with a few facts. They put lots of stuff in there. And again, that makes this, an issue that is now relevant, part of the indictment. And the defense can say, I want things that go towards, that you have in your possession that goes towards supporting my side. So, for example, the indictment says things like there was a national atmosphere, right? And the office's perceptions of public faith, in the election, that's in the indictment. So they're saying, so, okay, great. We want everything that's out there on that. Or, that there was foreign influence findings relating to the 2016 election, and the Trump issued an executive order instructing the director of national intelligence to assess this, right? I want all those reports. I want that because that'll go towards my good faith belief that the election was stolen from me and that there was fraud. And it's not for the prosecutor to decide whether or not any of these defenses have merit. They're putting it out there that these are their defenses. And it's clear that Donald Trump is going to relitigate what he has litigated already in the courts, that there was fraud in the election, that he believed it, and he's going to look for absolutely anything he can to prove that, or to show that, or to show that he had that belief in good faith, and therefore he wasn't trying to do anything other than question it, because look at all the stuff that's out there. So this, I don't like this motion. It'll be interesting to see how Jack Smith responds and what the judge ultimately says about it.
So my two takeaways on the motions that have been filed is there's two things missing. Well, there's one thing missing and one thing horribly conflated by Donald Trump that I don't think will get past Tanya Chutkin, the judge. First thing is he doesn't carry his burden in any of these motions to demonstrate that any of this information exists. Just listing in a motion practice all of the major agencies of our federal government and all of the lawyers who draw a paycheck from the federal government and suggest that maybe somewhere, if you let me in, judge, to their filing cabinets, electronic or real, I'll find something that'll help me in the case. That once the government has produced what they've produced under any of these cases, somebody in the chat said, why do legal cases, why does the law have such weird jargon? Because it's usually named after a case and you don't have any ability to pick your case. If the case makes that precedent, that's the name, that's what we refer to that concept as I used to joke, and it's true. In Florida, the leading case on the issue of personal jurisdiction over a person is called Venetian salami. Not kidding. So you got to stand up in court and say, well, judge, under the Venetian salami standard. When I first moved there, I was like, I have to say Venetian salami out loud? That sounds ridiculous. But you're stuck with it, whatever the name. That's why all the things that Karen referenced are all names of cases, Brady, Giglio, and all of that. So I don't think they've carried their burden. I think you've done a good job outlining the lack of connective tissue between the things that they say may exist and any argument that it really does exist. And the other is this conflation. This is Donald Trump, until he made his filings and 3 years later and got his third round of lawyers, has always argued that the big lie, the fraud is there was fraud in the election that was outcome determinative at the ballot box, through software, through hardware, through stuffed ballot boxes, through dead people voting at the ballot box. That's the fraud, not outside influence, unless the outside influence by Iran, China, Venezuela, Russia, India, and the like is causing votes to flip in the box. The fact that there is and has been for decades attempts by foreign powers and foreign enemies of our state and state actors to try to put Americans at each other's throat and cause discord and make them vote a certain direction, manipulated through social media and disinformation campaigns. That's been going on. I mean, it's not a spoiler alert for anybody, I hope. That's an audience here. That's been going on for 30 and 40 and 50 years. We do it in certain countries. So people who fall down the rabbit hole on social media or on the dark web, who think that they're being influenced by a fellow American, may well just be influenced by a Chinese spy or a Russian troll who wants Americans to hate each other and divide America, because we are allegedly the only superpower, maybe with China, and the weaker we are, the better it is for the rest of our enemies. And so that's election interference. That's interference by way of trying to get people influencing who they vote for. That's not the fraud. The fraud that Donald Trump used to bang on the heads of state secretaries of state in Georgia, election officials, elected officials, speakers of the House of various states and the battleground states, members of Congress, was the election was stolen. Votes for Biden should have been for me. There was software and hardware and a thumb drive in Georgia that flipped votes, and Chinese bamboo ballots and all the other. You can just spend the entire podcast listing all of the crazy QAnon theories. That was the fraud. Now you have this conflation in the middle of all their motions, which is we need to get to the bottom of Russian interference. And by the way, we think there was Russian interference in 2016, or as I said on my hot take, he finally did it. He finally admitted that Putin got him elected president. And so that's different. And so he can go search for that needle in whatever haystack he wants, but that's not the case. That's not the indicted case, and that's not what's been brought against him. He wants to put on this new cape. He wears basically two capes. First Amendment man, I can do and say anything. As core political speech because I'm the leading candidate for president. Wrong. That's a complete misstatement. Turns First Amendment law on its head. Secondly is I am foreign interference protector man. That's all I was doing. I didn't want to stay in power any longer than I had to. I was just looking for foreign interference and influence by the Chinese and all those other people. And that's all I was doing. And then he thinks that defeats mens rea or criminal mind or criminal intent because he didn't have criminal mind. I didn't want to commit a crime. I wanted to solve a crime. I was undercover and all the other craziness. It makes for great reporting like we're doing here and pages and pages and pages of filing that you and I have to go through. But fortunately, Judge Chutkan, as the gatekeeper, I believe is going to sift through all of this and maybe grant a couple of things here and there, but she's not going to expand the prosecution team to include every prosecutor, the Department of Justice, wherever they may reside, who may have touched a file related to Jan 6th, right? And he's trying to argue that the other interesting thing was trying to attack the prosecutors and arguing that they've taken inconsistent positions in the January 6th defendant cases, and those words should be used against the prosecutors here. And there is a body of law that says prosecutors can't take inconsistent positions across multiple cases that are somehow related. But they never said Donald Trump wasn't responsible for his own criminal conduct in those cases. They just told the court and the judge and the juries, and in sentencing, they just said it's no excuse that these people thought they were following their fearless leader and their cult leader in storming the Capitol. They can't say, I was ordered to do it. I just did what the guy said. And that, don't I get off for that? No, you don't get off for that. But that's different than since they can't blame Donald Trump is absolved of criminal conduct because of the position the prosecutors took in that case. It's almost a head scratcher, but it won't be fortunately for Judge Chutkan, who I think is going to very quickly, with like a giant, just blade, like whoosh, just cut down all of these arguments, give him a couple of things here and there and say, gentlemen, everybody, ladies and gentlemen, we're going to trial in March. You got what you needed. I'm satisfied with the government's representation that they've satisfied their Brady and Giglio requirements and Jenks requirements in providing you all the material that you need. She may find interesting and do an oral argument, and we'll report on it, on a couple of them. The only one open for me is, did the special counsel's office rely on investigatory material of other agencies of the federal government, like Homeland Security, Postal Service, and things like that, Department of Defense, as part of their indictment or their process? And should you include them in the definition of prosecutorial team to require them to turn over documents that reside in those different departments, offices, and computer servers or not? That for me is interesting, and I want to see that debated, and it will be, and we'll report on it, right here on Legal AF and in hot takes that you, Ben, and I do during the week. Let's wrap up the show, Karen, with you leading a Manhattan DA. I'll just remind everybody, there is a case that got first filed. It was the first out of the box. Manhattan DA's office broke the ice, broke the glass ceiling. They indicted Donald Trump for something. It just happened to be for something that people were like scratching their head, like, that's the one he got indicted on, which was the Stormy Daniels hush money cover-up business record fraud case, which is fine. You know what? Everybody laughed and critiqued and criticized Alvin Bragg. When you interviewed him, the Twitterverse went crazy about him. But, he got 17-count felony conviction against the Trump Organization for tax fraud. He put the CFO in jail and convicted him of multiple counts of tax fraud. And then he brought the one case now, and he still has time left on the clock to bring other cases as he's watching the New York Attorney General's civil fraud case be tried out. So I have nothing to say that criticizes Alvin Bragg so far. But that case was on the books in March. We know there was a phone call between the staff and perhaps the judge, Judge Chutkan, and Judge Merchan about trial dates, because it was reported that there was by court staff, and it's come up in the new proceedings. And it's still technically on the books to conflict with Judge Chutkan's trial in March. What do you know, Karen? What have you heard? What can you tell everybody about that? Ben, our colleague, likes to call it the not the zombie case, but the sleeper. It's the sleeper case that we don't talk about enough, but could be the one that helps bring down Donald Trump. What do you know? Tell our audience.
So that case, I like to call it not the Stormy Daniels case, but it was the first election interference case, right? This was him trying to suppress information from voters and becoming involved in election fraud. So, but what's happening in that case is, there's a placeholder, right? The Judge Merchan is not moving his trial date. It's I think it's March 24th of 2024, and some people might say, well, how could that be if Judge Chutkan is supposed to go March 2nd, I think, or March 4th, whatever it is, right in the very beginning, the first week of March in 2024, that won't be done. How could this case be scheduled? And what Judge Merchan, the state court judge in the New York case, is doing is saying, look, I'm no dummy. I know, because I'm a judge, that cases may or may not go all the time, right? Just because it's scheduled for that date, it might not go. Cases get pushed. So if that case gets pushed, my case is going. So he's keeping it there, but it could get pushed if Judge Chutkan's case does happen. What recently happened was the prosecutors at the Manhattan DA's office, my old office, they filed their opposition to, in response to, Trump's omnibus motion. And in New York State practice, the way we do it is a person gets arrested, they get arraigned, and then the case gets adjourned for a motion practice. And essentially what that is it's put everything you want to say in a motion now. They call it an omnibus motion, meaning it's everything you possibly want to do. You want to have statements suppressed and identification suppressed, evidence suppressed. You want, arguments that, whatever your arguments are, right, that you have as a defense attorney, put it all in one omnibus motion, and then the prosecution responds, and then you have hearings as to some of the issues if they warrant them, and then you go to trial. And that's kind of how it works. So Trump filed his omnibus motion, and the prosecution filed a 99-page response. And I thought it was extremely powerful, and it had many, I think it had like 6 or 7 sections. And they really did a great job at calling out Trump where he was being disingenuous. Like in one particular place, they said, look, they said Trump is being disingenuous about the effect of this case on his campaign, because he's saying, that this case is like hurting his campaign. Yet they pointed out his frequent public pronouncements that the indictment has actually strengthened his candidacy. And they also laid out, because one of the issues and one of the things that Trump argued was that the statute of limitations has passed, and there's a 5-year statute of limitations in this case, but the case took, I think, 6 years and 6+ years to go forward. So how is it possible that happened, given the fact that, it's not within the 5 years? And they did a great job saying, look, the case was brought 6 years and 44 days from the last entry in the false records. And so what the prosecution said was, look, we have to find at least 409 days where the statute of limitations was paused, or told is the word And they spelled it out. They said, look, during that period of time, there were two major tolling periods. One was COVID, where Governor Cuomo filed an executive order pressing pause on all statute of limitations in New York. And so that was a 412-day pause. And also, guess what? Trump was president for more than 409 days. And because he couldn't be apprehended. Why? Because he was continuously outside of the jurisdiction, being president of the United States, where he obviously can't get arrested, and he was busy doing other things. And so for those reasons, the statute, the 5-year statute, is tolled. And also there's also a constitutional speedy trial, meaning you can't unreasonably delay for constitutional reasons. And they spelled out, we didn't unreasonably delay bringing this case. We only learned about it in 2018 after Cohen pled guilty, right? Don't forget, the Southern District of New York, the federal prosecutors in New York prosecuted Michael Cohen for this. And then it was a very public plea. And the Manhattan DA's office routinely learns about cases in the news and opens up investigations, and that's what they did. And as soon as they opened up the investigation and the feds found out about it, they asked the DA's office to press pause and let them finish their investigation, which they did. And 10 months later, that's when the DA's office recommenced the investigation. And as part of the investigation, they were looking for tax and financial records, and they subpoenaed Mazars, the accounting firm for Trump. But this litigation took time. It took, I think it was 2 years. Almost 2 years, and didn't conclude until February of 2021. And the Manhattan DA's office had to go to the Supreme Court twice and argue in the Supreme Court twice to get those records. I even went to one of those arguments, actually, and watched the argument in the Supreme Court. And they finally got the tax records. And right after that is when they brought the case that you just referenced, the 17-count conviction that happened. They brought that case, and then they brought this case. So there was no delay, and they were very clear about that. And they really did a good job, I thought, spelling all of that out. The other kind of big picture issues that they spelled out that I thought was really interesting was that they basically said there wasn't sufficient evidence before the grand jury, and that they didn't have enough evidence, and that the records don't count as an enterprise, which is one of the elements of the crime. But the major thing that they talked about, I think, was that falsification of a business record in New York is a misdemeanor unless you're doing it to either commit or conceal a crime. And that's always been the rub in this case. People have kept saying, what crime was he either concealing or committing, and to bump it to a felony. And Alvin Bragg, the Manhattan DA, was a little bit, didn't commit to what it was. He said, look, it could be this, it could be that, but we don't have to tell you. We don't have to commit. You don't even have to, the jury doesn't even have to agree. It's just like burglary in New York, which burglary is essentially a trespass, okay, which is a crime, entering and remaining unlawfully somewhere. That's the elements of trespass, and that's a misdemeanor. What makes it a felony is with the intention of committing a crime therein, okay? You're trespassing plus you have the intention of committing a crime. Most of the time when you charge burglary as a prosecutor, you have no idea what crime that guy was going to commit, because half the time they get caught in the act right before they got to even complete, hopefully before they got to complete whatever horrible crime they were going to commit in there. It could be anything, right? And so there's a case in New York, People versus Mackey, and it's a long-standing precedent that you don't have to do that. And they were just saying, look, they don't have to do it here either. And that's what they've always said. But in this motion, and the thing that I thought in this motion that was so compelling is they kind of committed. Right? They actually spelled out the crimes in detail of what crimes the defendant intended to commit or conceal. And, it's very common. You would put your strongest argument first, right? Like that's how you always say, you call it primacy and recency, Popok. That's what you say. And that's a lawyer thing. And they're going to put their strongest argument first. And what crime did they pick? They leaned into federal election campaign or the federal election crime, right? And the reason that's significant is for a long time people were debating it doesn't count. A federal crime can't count as a bump up to a state crime. And rather than running away from it and saying, oh, it could be tax fraud that Michael Cohen was going to commit, when they grossed up the wages, or it could be something else. They leaned into it and they said, no, it's a federal offense. That's the case. That's what they put first. They gave the argument for it. And then they said, guess what? We looked through all our records. Many, many, many other times we have brought cases where a federal offense is the bump up. They argued the law and they argued the statute, and they basically hit a home run and leaned into it. And I loved that they did that.
I thought that was the best part of their briefing, which was to say that the defendant does not identify one person who is alleged to have committed the crimes that are in the indictment that was not indicted by the office. In other words, anybody that had that set of facts or anything close to it, it has been indicted. And so you don't have selective prosecution. And particularly, they said that the people, which is the Manhattan District Attorney's Office as prosecutors, regularly prosecute first-degree falsifying business records. But you're so right about the leaning in. I always said, and you and Ben and we all three of us said, the bump up has to be the election fraud, that he did it for a reason. It wasn't covering it up because he didn't want Melania to know about the affair. He was doing it because he didn't want the American people to know about the affair, right? He didn't want to be brought down the way, Bill Clinton almost lost his election when all these, the series of women came out from Paula Jones and the other Jennifer Flowers and all the people during the campaign trail. People forget about all that. And he didn't want that to happen to him. And that's why he tasked Michael Cohen and Alan Weisselberg and the guy that ran the National Enquirer, Mr. Picard, to make it go away. And that's the crime. And that's the rationale for it. And every judge that's taken a look at it, even Alvin Hellerstein, the federal judge who got to look at the case for a moment when he tried to remove it to federal court, said that's the crime is the election cover-up, or as you called it, election interference. So we have done a whirlwind tour and an update in all the different jurisdictions for civil and criminal cases involving Donald Trump. Some person asked me snarkily recently, is that all you guys do? Might only do Trump? No. Answer to that is no. We are covering whatever we do curate the episode, but we cover whatever we think is important at the intersection of law, politics, and justice, whoever that may be. I've done a fair amount, so have you, and so have Ben, of hot takes on abortion rights, on constitutional rights, on voting rights, on the attempt to disenfranchise people and suppress the vote, on a woman's right to choose. We don't shy away from these stories. We're not just here to like, oh, how many views did we get? Oh, great. Our popularity does help keep us on the air. It is right, as in any business model, anything on television or YouTube, but we take on the hard cases and the hard matters. So if you like what we're doing, and if you've been with us, we've had a big group with us tonight. We're number 3 or 4 in the world on YouTube Live tonight. Welcome back. If you have no idea, you just stumbled into Legal AF today, it happens. Welcome. This is what we do Wednesdays, Saturdays, 8 p.m. Eastern time. And then we do hot takes, the leaders of Legal AF, about every hour at the intersection that we've been talking about all night. And if you want to know how to support what we do here, we are an independent media company, meaning we don't take outside investors. We're grassroots. Somebody wrote in a chat recently, will you open your books to your business model? To which I wrote, oh, yeah, as soon as you do it. I don't understand what the problem with being independent means. I mean, would you rather us not be? We are. And so the way to support us is really viewer audience driven and listener driven for our podcast that's on the audio platforms. Watch us here. The thumbs up isn't just fun. It helps us, helps the algorithms, keeps the ratings high, keeps us in the content on the air. Plain and simple. Then on the audio podcast that'll drop in a few hours, go pick it up there. Free. It's free to subscribe to the Midas Touch YouTube channel. Help them get to 2 million, because that's really important to what we're doing here. And that's free. Go listen to us for free on the podcast. And if you want to spend any money, you can. There's Patreon to support the Midas Touch Network. We might roll out a Patreon come the new year for Legal AF people. There's T-shirts you can buy at store.midastouch. Whatever. Store.midastouch.com. I don't know why I always stumble on that. There's some, if you want to fly the flag of Midas Touch and Legal AF, there you go. There are some opportunities to do that. But these are the ways that you can support us. And then we've got our sponsors, because we have to have a business model. Otherwise, what are we doing? So that, we have interesting products. We pick them, we curate them, and we like them, we try them, we get them, and we talk about them on shows like this. So supporting our sponsors is important as well. So until the next series of hot takes, until the next Legal AF, which is this Saturday, I'm Michael Popok, and we have Karen. Introduce yourself again.
Karen Friedman Agnifilo.
Yes, and this is Legal AF. Shout out to the Midas Mighty and the Legal AFers. See you next week.